India, our chief guest, to kindly deliver his address.
Mr. Ravi Shankar Prasad, the Honorable Minister for Law and Justice, Mr. K. Venugopal, the Attorney General for India, Mr. Dushyant Dave, the President of the Supreme Court Bar Association, Mr. Kailash Vasdev, Vice President, my distinguished colleagues, Mr. Rohit Pandey, Mr. Manish Dubey, advocates, ladies and gentlemen. Earlier this year, the whole world was struck with the tragedy of the coronavirus, and many lost their lives on account of the spawning pathogen. It is a platitude that courts of law, like every other public institution, have encountered unprecedented challenges on account of the corona pandemic. The biggest and the highest priority on the list of challenges that the courts faced was delivering unhampered access to justice in the midst of a nationwide lockdown. It became alarmingly important that in such circumstances, access to justice is ensured, since it is that facet of the rule of law that instills a sense of security and well-being to its citizens. I began with this on the Constitution Day because it is for the first time in many years that the courts encountered that there can be a sudden shock and a sudden interruption of its functions on account of a totally unexpected factor that could disrupt the functioning of courts and therefore hamper the rule of law itself. In doing so, the courts had to encounter a web of problems, one interconnected with the other. For a system so heavily dependent on books and documents, cutting off physical contact amongst people had to be the first step to prevent the wildfire spread of virus amongst lawyers and judges and other court staff. The physical filing of the cases had to be stopped, and entry of persons to the court premises for any congregation had to be prevented. This brought out many significant handicaps, ranging from courts not being equipped with video conferencing facilities to lawyers not having access to such equipment. Judges had to learn to distance themselves from their own staff because even though the advocate's entry to the court premises was stopped, the court staff was still working. I do not wish to go into any more negative facts, but today, as we speak and celebrate the Constitution Day, I must tell you that the coronavirus had hit the hardest blow to the court and its staff. While physical distancing was a step taken to overcome the hurdle of continued access to justice for the common man, it led to the creation of a new kind of equality. And I take this opportunity to speak on this occasion in the Bar Association about this inequality. This is an inequality spurred by the virus which made justice dependent on access to technology. Those who did not have access to technology did not have access to the system of justice itself. To bridge the gaps that existed, the Supreme Court identified places in districts and set up kiosks and mobile vans for lawyers and litigants, mobile vans carrying Wi-Fi for lawyers and litigants who did not have video conferencing facilities so that they could go to these identified places and appear virtually. There is much remaining to be done in this regard, but the Supreme Court continues to be engaged in solving the problems of delivering justice and reversing the inequality that has crept in. I must, on this occasion, acknowledge the solid support I received from the Supreme Court Bar Association and from members of the other high courts Bar Association in meeting this, what I would consider a catastrophe. Please remember that we have in fact generated an inequality which will soon be removed. It is very, very unfortunate to visit the districts in India, which I have done as Chief Justice, and to be told that for a large section which does not have access to technology, the courts do not simply exist. For the members of the bar, the result of the pandemic has been interesting. Whereas earlier advocates went physically to different appear in the courts of that jurisdiction, now the advocates can do so by simply shifting from one chair to another, which has a different computer in front of it. Many senior advocates have set up multiple computers, each connected to different courtrooms, and with a mere shifting from one screen to the other, can connect to various courts in this country. This increased access has led to an exponentially enhanced opportunity for these lawyers. But there are also those who have suffered due to the lack of access to such facilities. Time and again, I have been told by junior lawyers that they have found themselves greatly disadvantaged because they are briefless without physical courtrooms. Even in ordinary times, contrary to popular perception, legal practice is a steep uphill climb for most lawyers. Earlier, when they attended courts physically, they would get cases. Due to the loss of cases and thereby loss of income during the pandemic, some members of the bar in Orissa and Mumbai even took to odd jobs like selling vegetables to sustain themselves financially. This is something that has never happened before in the profession of law. I am conscious that I am not saying from the theme of the Constitution because I am talking of perceived equality and the denial of access to justice, which is a constitutional impediment. The impact has been different on civil trials and criminal trials. A senior arbitrator reported that it took twice the amount of time to take evidence in conducting arbitration via video conferencing. This video conference is something which we have got used to, but it still feels slightly unusual to us, and not everybody is comfortable with a virtual hearing. At this stage, I must acknowledge the unstinted cooperation of the Union Ministry, particularly of IT, headed by Sri Ravi Shankar Prasad, in the help they have rendered to the Supreme Court. As courts of our highest duty is to uphold the vision of that venerated document, the Constitution of India, which has been handed down to us by our forefathers to preserve the liberties of citizens against the state's demand for law and order. The framers of the Constitution have struck a resilient balance between liberty and the right and condition on which the state can deny it. The freedom of speech and the restrictions on it are in the interests of the reputation of individuals and institutions. Nothing is conferred as a right or freedom in absolute, untrammeled terms. I agree with what Dushyant Dave, the president, said that the Constitution has been framed by possibly the greatest Indian minds that worked then. I would like to add, because that is what I like to think, that is certainly true of the time, but I would like to think that the greatest Indian minds are yet to be born. It is this resilience that has allowed the courts to carry on through the pandemic and ensure that the vibrancy and the supremacy of our Constitution is maintained. The framers envisaged that it must survive for long years to come. The basic structure doctrine developed in the famous case of Keshwanand Bharati held that it is not only required that the Constitution survives, but also that the Constitution survives and functions with all of its essential features and values which cannot be severed. Many scholars refer to this as resilience in its thickest sense, because the Constitution not only survives major attacks and challenges, but also remains true to its central mandates and values, thereby maintaining its essence as the country travels through troubled waters, and indeed has traveled through troubled waters over years. The respect for the judiciary as an institution is respect for our shared concerns of upholding the rule of law. The judiciary has been entrusted with the interests of balancing the interests of the state and the freedoms granted by the Constitution to the people. It has, to a large extent, operated on the wisdom of the old saying, while balancing rights, that the right to swing your arm ends where my nose begins. Not just during the pandemic, over the years, the judiciary has worked through conditions which are truly adverse. It has moved through different phases, but its commitment to improving access to justice has remained constant. I don't know how many from the Supreme Court bar have seen courtrooms where judges have delivered justice sitting in verandas. Advocates carry out their practice sitting on wooden boxes. There was a time when I know of a session judge who had cases of powerful offenders belonging to organized gangs on his board, but he had no choice but to travel by local trains, feeling completely at the mercy of whatever might happen. Here I must say that the executive has admirably responded to the plight of judges. The pay scales have drastically improved, and district judges have now laptops and cars, and if necessary, physical security. In upholding the Constitution, myriad problems arise in a nation of perplexing diversity. I dare say that the judiciary has proven equal to the task. It is with some sense of achievement we say that the Supreme Court of India was not locked down even for a day. This is particularly important because a huge percentage of matters involve fundamental rights and the protection of more vulnerable members of our community, especially older persons, the victims of domestic violence, and in general, all those who need it. I must acknowledge what the learned Attorney General pointed out with great accuracy, the problem of pendency of cases. I'm sure we all know, and certainly the learned Attorney General, who has possibly the highest experience of anybody in this congregation, knows that the best minds in the judiciary and the bar and sitting in law commission have dealt with this problem of arrears and have not been able to really contain it over a period of, say, maybe 60 years. That is when the problem arose. I am not diffident and neither would I like to sound pessimistic, but I think it is high time that we resorted to some system like that of pre-litigation mediation, which has the force of a decree. It is something which I believe will work and is probably the only thing which is going to contain this pendency, especially the huge pendency that is going to arise as soon as the lockdown is lifted. Pre-litigation mediation is something that would work because it addresses disputes before litigation begins. And we all know that every dispute does not require learned arguments or application of constitutional principles. The learned law minister and I have discussed this matter at one stage, and I do hope we find a solution in this direction as soon as possible, because the I have more statistics than what the learned attorney general has, which I am not taking. The problem is going to be enormous. As we gather here today to pay tribute to our constitution, we are reminded that it's not merely a document on paper, but a synthesis of the ancient and modern wisdom of our country. It is the embodiment of the hopes and aspirations of our people, the benefactor to those in need, and the protector of our liberties. May this document shine us a guiding light and lead us all in our journey today and in the years to come. Thank you. Jai Hind.
Thank you, Lordship. It is in the